Report of the Center-State Relations Inquiry Committee, Government of Tamil Nadu, 1971, read by Ramani, Chapter 6. Central Planning and Planning Commission. There was no legislative entry in the Government of India Act 1935 relating to planning. There is now an entry in the concurrent list on economic and social planning. But up till now, no law has been enacted by Parliament in exercise of this power conferred by this entry. The Planning Commission itself, concerned with economic and social planning, was not constituted by law. There is no provision in the Constitution for the establishment of a body like the Planning Commission, similar to Article 280, which provides for the appointment of a Finance Commission. The following remarks of the Chairman of the Fourth Finance Commission in his supplementary note to the report emphasize the need for giving a statutory base to the Planning Commission. Quote, there is no provision in the Constitution for a body like the Planning Commission. It was established by a resolution of the Government of India. Neither the strength of the Commission nor the qualification of its members was prescribed. The Government retained complete freedom to vary its strength at will and to appoint anyone as a member. There was no limit to the duration of the Commission. When it was constituted, possibly it was meant to be a temporary body, and in a sense it continues to be so, though obviously it has come to stay. The composition of the Commission is unusual. It has, as its chairman, the Prime Minister, and among its members there are cabinet ministers. When compared to a statutory body like the Finance Commission, which is quite independent of the government, the Planning Commission may be described as a quasi political body. There has been from time to time variation in the strength of the Commission and in the appointment of its members. Though its role is advisory, it has come to occupy a very significant and important place in the economic development of the country. Vis-a-vis the government, it's not easy to describe its status in spite of its importance. It remains to this day a body without any constitutional or legislative sanction, as the entire plan, both as regards policy and program, comes within the purview of the Planning Commission, and as the assistance to be given by the Centre for planned projects, either by way of grants or loans, is practically dependent on the recommendations of the Planning Commission. It's obvious that a body like the Finance Commission cannot operate in the same field. The main function of the Finance Commission now consists in determining the revenue gap of each state and providing for filling up the gap by a scheme of devolution, partly by a distribution of taxes and duties, and partly by grants and aid. Personally, I have no comment to make on such a dichotomy of functions, but I think that the relative scope and functions of the two commissions should be clearly defined by amending the Constitution, and the Planning Commission should be made a statutory body independent of the government. Unquote, pages 89 to 90. Thiru K. Santhanam, in the course of his lectures delivered in March 1959, which we had occasion to refer to earlier on, has drawn attention to the basis on which the Planning Commission started working. According to him, the basis was, quote, that there would be practical uniformity of policy over the entire sphere of administration, both in the Union and the states, unquote, and that, quote, almost all the states were almost similar, if not identical, unquote. He also refers to the assumption, quote, that the conditions in all the states were similar and similar programs requiring same administrative action and similar methods of financing should be adopted in all the states. Unquote. In his view, the Planning Commission has set up a sort of vertical federation, thus displacing a territorial or horizontal federation established by the Constituent Assembly. He is emphatically of the opinion that planning has superseded the federation And our country is functioning almost like a unitary system in many respects. Dictation from the central to state ministries is inconsistent with the true spirit of state autonomy. The Constitution provides for a particularly strong paramount center with full power to control the states in all essential matters. This has been accentuated by planning, which has brought about an almost military state for purposes of economic development and financing. Political influences have also helped to emphasize this centralization. The study team appointed by the Administrative Reforms Commission has this to say about the consequence of planning. Quote, as a result of planning, the three horizontal layers of administration, represented by lists of central, concurrent, and state subjects, have been vertically partitioned into plan and non plan sectors, and within the plan would the compulsions and consequences of planning have tended to unite the three horizontal pieces into a single near monolithic chunk controlled from the center, although operated in respect of concurrent and state subjects in the states. Unquote, pages 95 to 96 of Volume 1. The absence of constitutional and legal provisions relating to the planning has tended to create in the states a sense of helplessness and complete dependence on the center's bounty. Consequently, the center has made serious inroads into the spheres exclusively assigned to the states. Dr. K. Subbarao, in his Lal Bahadur Shastri Memorial Lectures delivered in March 1969, comments on the role of the Planning Commission thus, quote, the Planning Commission constituted in India functioned in violation of the provisions of the Constitution. That's possible because the same party was in power in the center and the states. It had grown in prestige by its intimate connection with important cabinet ministers of the center and by its control of the nation's economy. Over the years, it has developed into a super cabinet. The center, through the Planning Commission, controlled not only the state sector of the plan but also their implementation. Unquote. Though the states prepare plans for their areas in the light of the particular targets suggested in the draft plan prepared by the Planning Commission, the final shape of the plans is determined in the light of the discussions between the Planning Commission and the representatives of the states. The center is able to impose its will on the states in the formulation and execution of the plans by virtue of the non statutory grants under Article 282, which are dependent on the absolute discretion of the center. It will thus be seen that the process of planning and the activities of the Planning Commission have a very deleterious effect on the autonomy of the states, particularly in spheres exclusively allotted to the states by the Constitution. The Administrative Reforms Commission, in its report on machinery for planning, has made some suggestions regarding the assistance to be given by the center to the states for purposes of planning. The recommendations have been set out in paragraph 4 at pages 10 to 11 of its report on center state relationships. At the instance of the state governments, the question of determining objective criteria for distribution of central assistance to states for planned schemes was placed before the Committee of Chief Ministers of the National Development Council early in 1969. The new principles of allocation settled by the National Development Council have been accepted by the central government, and finances for schemes under the 5 year plan are to be allotted on the following basis: A, 60% on the basis of population, and B, 10% each on the basis of 1. Per capita income if below the national average, 2. Tax efforts in relation to per capita income, 3. Commitments in respect of major continuing irrigation and power projects, and 4. Special problems such as floods, chronically drought affected areas and tribal areas of individual states. Under the new scheme, which has become operative from 1969 to 70, central plan assistance to states is determined on the basis of the formula devised by the National Development Council will be given through block grants and loans and will not be tied to specific schemes. However, central approval will be required for major projects and for certain major sectors like agriculture and education. In order that the states may have greater freedom in the drafting and implementation of their own plans, the number of centrally sponsored schemes has been greatly reduced. Detailed sectoral planning and preparation and execution of individual schemes and programs have been left to the state governments. As regards centrally sponsored schemes, which are to be wholly financed by the central government, we may point out that the states are as much concerned with the so called central schemes as with the state schemes. Any scheme under the 5 year plan, while benefiting the territory concerned, is ultimately intended to improve the economic lot of the nation as a whole. This applies to central schemes also. It's neither desirable nor expedient to exclude the states from participation in them. The schemes are situated within the state, and as the scheme progresses in its implementation, the state has to take upon itself certain responsibilities such as acquisition of sites, measures regarding public health, and more important than anything else, maintenance of law and order. We would, therefore, suggest that the states should be closely associated in the formulation and execution of even centrally sponsored schemes, and, if necessary, the states may be required to make such contribution as is within their financial capacity towards these central schemes also. Where a central scheme benefits a particular state or a region, the general taxpayer should not be asked to shoulder the burden resulting from the scheme. Some device should be formulated for the state or region concerned to take up the financing of the scheme either directly or by levy of betterment contribution. We have, while dealing with the Finance Commission and the scope of Article 282, dealt with the Planning Commission also. If a suggestion that the grants under Article 282 should be routed through the Finance Commission is accepted, one of the major functions of the Planning Commission would have been taken away from it. The question then is what functions should be entrusted to the Planning Commission? As at present, the Planning Commission will continue to deal with the formulation of plans. We have referred to the legislative entry bearing on the subject in more than one place in the preceding paragraphs. This is an item in the concurrent list. No law has been enacted under this entry. We consider that if the Planning Commission is to fulfill the objective with which it was originally set up, its composition and functions should be placed on an independent footing without being subject to control by the Union Executive or to political influences. This object could be achieved only by placing it on a statutory basis. A law may be made by Parliament providing for the establishment of a planning commission. It should consist of only experts in economic, scientific, and technical and agricultural matters and specialists in other categories of national activity. No member of the government should be on it. The law establishing it will have, of course, to deal with the tenure, term of office, and conditions of service of the members of the Planning Commission. It should have a secretariat of its own. It goes without saying that the Planning Commission, as now constituted, has to be abolished. The function of the Planning Commission will be to advise on schemes formulated by the states. Each state may have a planning board on the same lines as the Planning Commission at the center. The central authority will also have the additional responsibility of making recommendations for consideration by the Finance Commission regarding grant of foreign exchange to states for industrial undertakings started by or in the states. Planning and development. Industrial development is one of the principal objects of planning. Any activity relating to such development is now regulated in large measure by the Industries Development and Regulation Act 1951. While dealing with entry 52 of the Union list in the chapter relating to distribution of legislative powers, we had touched on the scope of this act. We have there recommended that entry 52 should be recast so as to limit its operation to industries of national importance or of all India character or to industries with a capital of more than 100 crores of rupees. It follows from this recommendation that the Act of 1951 has to be repealed and replaced by an act providing for the control by the center of only such industries as we have referred to above. The provisions relating to grant of licenses should be completely omitted. The state should have the power to grant licenses to start new industrial undertakings within the state, either in the private sector or in the cooperative sector. The states should also have the power themselves to start and carry on industrial undertakings in the public sector, except in fields reserved for the Union, with or without foreign collaboration. If foreign exchange is required for any industrial undertaking, licensed or started by a state, it should be provided by means of block grants to be allocated to each state. This allocation may be increased on the recommendation of the Finance Commission made in consultation with the Planning Commission.